Hello and welcome to this third installment of our series on race and the 1L curriculum. My name is Professor Darrell Miller. I'm the Melvin G. Shem Professor of Law here at Duke Law School. I'm also the Associate Dean for Intellectual Life. And this is a series where we'll discuss topics related to race and the courses that are part and instrumental to the 1L curriculum. And today our unit is going to be on civil procedure. I'm really excited to have two excellent panelists and guests that are joining us for this webinar. As with all our series in this, programming in this series, if you have questions about how any one of these topics sort of plays out in practice, or any questions to the panelists, you can use the Q&A function at the bottom of your screen. Our first guest is Professor Brooke Coleman. She's the Assistant Dean of Research and Faculty Development and Professor of Law at the Seattle University School of Law, where she writes on topics of civil procedure, advanced litigation, and federal courts. Prior to joining the Academy, she also clerked for our own Dean Emeritus, David Levy, in the Eastern District of California. She's the author of hashtag So White Male Federal Civil Rulemaking, a piece that she wrote for the Northwestern University Law Review. And she's going to be speaking on diversity and representation on the Rules Committee. That is the committee that actually proposes the rules of civil procedure that many of you are learning right now. Our second guest is Professor Suja Thomas. She's the Peer and Sarah Pedersen Professor of Law at the University of Illinois College of Law and an expert on summary judgment. She's the author of many works on summary judgment and civil procedure, as well as two books, The Missing American Jury, Restoring the Fundamental Constitutional Role of Criminal, Civil, and Grand Juries, and Unequal, How Courts Undermine Discrimination Law, which she wrote with my former colleague at Cincinnati, Professor Sandra Sperino. Welcome, Professor Thomas. I'm really excited to hear about these two topics. It's really relevant in terms of how civil procedure operates on the ground and how it's formulated. And with no further ado, I will cede the floor to Professor Coleman.
Thank you. All right. So I want to share my screen with you all and talk about So White Male. So first of all, thank you to Professor Miller for having me here. And it's always an honor to be on any kind of panel with Professor Thomas. So thanks for including me in all of this. So yes, I wrote this article called So White Male about the demographic composition of the Civil Rules Committee. And I want to talk to you all about that today. This article went out in 2018. But I've updated the data so I can talk to you all about that today. Where I want to start, though, is with something that I think is going to be a pretty easy sell with this group, and that is that the rules of civil procedure really matter. I'm sure if you've had Professor Miller as your professor, he's already made that abundantly clear. But here's just a selection of headlines that we can just look at and understand the impact that the rules of procedure have on civil litigation. So when we talk about things like discrimination on the basis of gender or sexual orientation, or even right now with the election, we're seeing how important the rules of procedure are with respect to class actions or discovery or pleading. So the rules really matter. And what my work does is it asks the question of who is making these rules, who actually creates the rules of procedure. Now, this is something that I didn't even know when I went to law school. I'm sure you all are learning more about that than I am, but just in case, I want to go over it. As Professor Miller mentioned, I didn't learn anything about the rulemaking process until I went to go work for your former dean, Judge Levy, when I had that great job working for him at the standing committee. So what I want to do is go over this process fairly quickly. In 1934, Congress adopted this act called the Rules Enabling Act. And what that did is it gave to the Supreme Court the power to create the rules of procedure. So basically, Congress said, we don't want to make the rules of procedure for the federal courts. Supreme Court, you go ahead and handle that. What the Supreme Court did is it appointed the very first advisory committee on the federal rules, and this one was about civil procedure. They created this committee. Back then, it was mostly academics and practitioners, and they drafted the rules largely the way that we have them today. So that was in 1938 that those rules were promulgated. Over time, the system of the rulemaking has changed, and it's gotten a little bit bigger because, as you can see on the slide, we now have 6 committees. We have the Standing Committee, which oversees the appellate rules, the bankruptcy rules, civil, criminal, and evidence. And the appointments to these very powerful committees are made by the Chief Justice of the United States Supreme Court. So that's Justice John Roberts, who appoints the members of these committees. Now these committees are mostly made up of judges and practitioners, and then there's 1 or 2 academics on them to round them out. And the chief makes all of these appointments. Now, today, what I'm going to talk about is the demographic composition of the Civil Rules Committee, but I have a new article coming out this month that looks at all of the committees. So I'd be happy to talk about that in the context of the Q&A. Before we get to the composition of all these committees, though, we need to have a discussion around language and terminology, because that is incredibly important. In my work, what I've done is I've used the racial designations of the US Census Bureau, which is not the best source. But because I need information based on a larger pool which to compare it to, I needed to use the census designations because that's the largest set of information that we have around the demographic composition of our country. But as a lot of work has pointed out, the Census Bureau is under-inclusive. It doesn't allow for folks to really express their racial identity. So in that way, it is imperfect. The same is true for gender designations. When I look at gender with respect to my work, I look at men and women, and that is the data that I have. But we know that gender is not binary, and so of course this is also problematic. Finally, when I only look at men and women in this terminology way, we lose intersectionality. And what that does is it renders some groups invisible. So where I can, I've tried to get the information around not just women of color as some monolith, but whether there were Black women or Native American women and so on. The problem is there's not a lot of that data out there universally, but where I can, I've tried to pull that data out. So all this is to say that this work is imperfect, but it is my best effort to try to give you a sense of what the composition of these committees looks like. So the first place I want to start with is race, the racial composition of these committees that create the federal rules of civil procedure. And when we look at the racial composition of these committees, you can see it is very white. I don't think that very is a strong enough word. It was 96% white if we look at the composition of the committee starting in 1934 until early October of 2020. And essentially what I did was I looked at the membership of each of these committees, starting from them and up till now, and then researched the demographics of all of these individuals. And these are the folks, again, that the Chief Justice appoints. So it was 96% white over time. It is 93% white currently. So the current committee has only 1 person of color on the committee out of the 14 people that the Chief Justice appoints. So grossly underrepresentative of other races. When we look at gender, the picture changes a little bit, and it's interesting. This is recent progress. So as you can see right now, 50% of the committee is women and 50% is men. It's evenly divided. Over time, the committee was 87% women. So this is something that has changed. When I looked at this originally in 2018, though, there were only 4 women on the committee. So this is a recent change. Following the publication of So White Male, the chief appointed 3 new female members to the committee. So this is the first time that the committee has ever had more than 4 women on the committee at a time. This is progress, and I think we should think about it as such, but it is very small progress, because when we look at the intersection of gender and race, you can see that this is problematic. Not once has the committee ever included a woman of color. Not one woman of color has ever served on this committee, either historically or now. And when we look at men of color, there's one man of color. He's a Black man on the committee right now. But over time, there's only been 4 men of color on the Civil Rules Committee. So again, at the intersection of race and gender, we can really appreciate how very white this committee has been and continues to be. Now, one of the responses that I get when I do this work is that perhaps it's not that the chief is not making the appointments sensitive to race and to gender, but that he's making an appointments from a pool of candidates that are actually less representative on the basis of race and gender. So what I decided to do was to look at some of the pools of candidates that the chief can pull from. And the one I want to focus you all on today is federal district court judges. So now when we look at most of the committees, the lion's share of the judges on these committees are federal district court judges. And judges generally make up half of most of these committees now. So it's a huge pool of candidates that the Chief Justice has at his disposal. But when you look at this, and I've highlighted it for you, you can see that it is very skewed. So 93% of the committee is white, yet federal district court judges are 71% white. We can pause on that for a moment because that's a stark statistic as well. But when we look down at the other membership at the committee, you can see that there's only 77% of Black individuals on the committee, yet 14 or 13% of federal district court judges are Black. So the pool is larger and he's not pulling from that. Similarly, Latinx folks, 9% of the judiciary is Latinx, 0% on the committee, and 3% of Asian American folks on the bench, and yet 0% on the committee. Now, again, what I want to really point out is that the federal district court pool is already very underrepresentative of people of color and women. So it's already a pool that is very restricted. But even within that restricted pool, the committees are further restricted. In other words, it's even less representative of a group of individuals that is already not very representative of our general public or of even lawyers. So what I want to talk about finally as we close out is just why does this matter? I argue that it matters for 3 different reasons. The first is that expertise does not equal unbiased. So the federal civil rulemaking process, it relies on expertise, and I think it rightfully should. I mean, we need people who understand the ins and outs of the federal rules of civil procedure. But that expertise doesn't eliminate the potential for bias in decision making. And a committee that is actually more representative of men and women of men of color and women would not only mitigate those biases, I think that it would likely produce rules that reflect a variety of diverse perspectives and considerations that are otherwise being missed. In other words, I don't think that expertise eliminates blind spots. And so to the degree to which we can diversify these committees, we would be mitigating those blind spots, and it would be a better set of rules that would be produced. This brings me to my second point, which is that articulation of how blind spots and groupthink work are really, really followed up and supported by the social science that we have. When we look at decision making, we see repeatedly, whether it's in jury rooms or in boardrooms, that when you have a more diverse group of individuals making decisions, the product is better. Now, identity is obviously only one axis on which to think about diversity, but it is an important one. And so over and over and over again, we keep seeing that this is the better way to create things, and yet we are not making the effort to diversify these committees. And let's be honest, the federal rules of civil procedure are a product. They're a thing that we use, and the more diversity we have, I think it would be better off. The final reason, I think, is a moral one. The legal profession has a history of excluding men of color and women of all colors. There's no doubt that lawyers have made great strides in achieving more equality for marginalized groups, but the legal profession itself has this deep, deep history of exclusion. And I think it's incumbent upon us as law professors, as law students, as judges, as members of the bar, to really push on those in power to remedy remedy that exclusion. This one, to me, is fairly straightforward and simple. The chief has a pool of candidates to draw from, and he simply needs to make the choice to appoint those individuals to these very powerful committees. So that's the close of my presentation. I really look forward to your questions. Again, please go ahead and read my article if you're interested. I'll have another one out later this month. I also want to encourage you to email me. I'd love to hear from students across the country about these issues. And of course, there's my Twitter feed if you want to maybe hear about this even more. So thank you again for this opportunity, and I really look forward to your questions.
Thank you so much, Professor Coleman. Excellent. Well, we're going to move now to Professor Thomas, and then after that, we'll have some time for Q&A, but you can queue up whatever questions you have as you're thinking about them right now. Professor Thomas?
Yeah, it's so good to be here today. Thank you so much, Professor Miller, for this invitation. And as Professor Coleman mentioned, it's always so good also for me to be on the panel with her. Today I'm talking about civil rights. I want to start my discussion of this by telling you how I became interested in the subject of summary judgment and civil rights. So many years ago, I was a young lawyer in New York City working for a law firm called Vladeck, and it's a plaintiff's discrimination firm. And I represented a man named Doug McIntosh, who was African-American, who had complained that he had not been promoted because of his race. And then his employer, when he complained about discrimination, his employer fired him. So we brought a claim of discrimination and retaliation in a case in the Southern District of New York. And we had a jury that was very diverse. And the jury decided that my client had been retaliated against, and they awarded him back pay, and they awarded him emotional distress damages. So they awarded him $220,000. And so my client was very happy. We were happy, but everything changed in an instant. What happened was the employer said, instead of $220,000, my client should receive only $20,000. And the judge agreed. The judge said that instead of $220,000, my client should get $20,000 because a reasonable jury could only find $20,000, not $220,000. And I was shocked. I wondered, is this being used in civil rights cases, this procedure, which is called remittiture, the reduction of a jury verdict? Or is it the case that there's a problem with respect to the civil jury right? Is this constitutional? And I'm going to get to all of that in a few minutes. But I want to start by just backing up and telling you a little bit of a history of summary judgment, because I got from remittiture to summary judgment because that's another procedure that I think gets in the way of the right to a jury trial. So the history of summary judgment begins in England in the mid-19th century. There was an act called the Keating's Act, and that permitted a plaintiff who had a debt case owed to him to ask the judge to actually rule on the defendant's defense. They said that the defense was not genuine, and the judge would decide that whether or not the defense to this debt claim was genuine. So this was a very simple procedure that only the plaintiff could use. It expanded, but it didn't expand to cases that did not have factual clarity. So for example, it didn't expand to personal injury cases. And it was used in cases that involved written instruments like contracts. So we go over to the United States, and summary judgment is established in the United States. And as Professor Coleman mentioned, we have the Civil Advisory Committee, and they decide that there should be a procedure called summary judgment. And they decide that it should be able to be used in any type of case, even though there was concern that if we use them in torts cases, for example, that there might be an infringement on the right to a jury trial. And there was also a decision that both plaintiffs and defendants could bring motions for summary judgment, despite the history that only plaintiffs could bring motions for summary judgment. Okay, so this is the rule that we have, it states that the court shall grant summary judgment if the movement shows there's no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. And so where it fits in a case, just to review, is after discovery, the exchange of information between parties, then there can be a motion for summary judgment, or typically that's when we see the motion. And typically the defendant will say to the plaintiff, there's no genuine dispute of material fact, and I'm entitled to judgment as a matter of law. And then the judge rules on that. And that's about in the middle of the case before trial. And then there are these other procedures after trial that also allow a judge to question what the jury has found after trial. So before the trilogy of Supreme Court cases on summary judgment, there was a standard from the courts that a litigant had the right to a jury trial when there was the slightest doubt as to the facts. Well, this changed in 1986 when there was the trilogy of Supreme Court cases on summary judgment. And the United States Supreme Court decided, among other things, that there should be summary judgment if the case was factually insufficient, or in other words, that a reasonable jury could not find for the non-moving party. And I'm going to use the term plaintiff now because most of the time, as I said before, defendants are the ones who are making the motion for summary judgment now. So could a reasonable jury find for the plaintiff? So in the Anderson Liberty Lobby case, Justice Brennan criticized this standard, this reasonable jury standard. And what he said was this was like a game of telephone. So some of you may know about this game of telephone. You have a cup and you have a string and you say one thing and the person on the other end hears it in a different way. And the idea here, like this depiction, is that it becomes something very different from one cup to the next, from one telephone to the next. And Justice Brennan said that summary judgment was this at the beginning, and now it's this. It's totally distorted. It's not what it was supposed to be. And he said that we don't even know how we're going to decide what a reasonable jury could find. And so that has been one of the criticisms that I've made of summary judgment. So I've said the court hasn't described how a judge can decide what a reasonable jury could find, which is something Justice Brennan said. I've said that a court cannot determine whether a reasonable jury could find for the non-moving party. So I want you to all sit back and think about this. You're a judge and you have to decide what a reasonable jury could find in a discrimination case. And so how are you going to decide that? Are you going to sit back and say, okay, Professor Miller's going to be on my jury, Professor Coleman's going to be on my jury, we're going to have Rachel on the jury and another whole set of people on the jury. You're going to decide what each of them thinks about the evidence. You're going to decide what each of them says in the deliberation. You're going to decide what each of them actually decides after the deliberation. And we all know that's impossible. We don't know what's in each other's heads. We only know what's in our heads. And that's what's happening on summary judgment. And that's not allowed, right? The Supreme Court has said a judge is not supposed to decide what he or she thinks. The judge is supposed to decide what a reasonable jury could think. And what we see is evidence that all they're doing is deciding what they think. They describe what they see in the evidence. They disagree with one another about what a reasonable jury could find. So let me give you an example. So some of you know a little bit about the Scott versus Harris case. Let me very briefly describe. So that case was a case where it was an African-American plaintiff and he was driving his car 72 in a 55-mile-per-hour speed zone in Georgia. And he was driving, the police attempted to stop him, he kept going, and there was a video of this car chase. And a police officer received permission to do a pit maneuver, which is spinning someone to a stop. And instead of doing that, the police officer rammed the vehicle and the plaintiff, this young man, became a quadriplegic when the car went down an embankment. And so Mr. Harris sued, and he said that the police had exercised excessive force. And the case went to the trial court, and the trial court said a reasonable jury could find excessive force. The Court of Appeals said a reasonable jury could find excessive force. And the case went to the United States Supreme Court, and in an 8-1 decision, the United States Supreme Court said a reasonable jury could not find excessive force. In each of these decisions, they describe what they see, not what a reasonable jury could see. So for example, the Court of Appeals, although the Court of Appeals describes this as from the non-movement's viewpoint, they say that Harris slowed for turns at intersections. He didn't run motorists off the road. He was not a threat to pedestrians. By the time that the police officer ran the vehicle, the motorway had been cleared of motorists. Justice Scalia has a very different point of view. He says shockingly fast speeds, swerving, multiple red lights are run. This is a Hollywood car chase of the most frightening sort. And then Justice Stevens has a much different view of things. He says the cars were already out of pursuit's path, that Harris used his turn signal. He slowed and waited for cars traveling in the other direction. This was not a Hollywood car chase of the most frightening sort. There were no close calls. So you have people describing what they think, and you have a difference of opinion. And at the end of this, it's 5 versus 8. 5 saying a reasonable jury could find, 8 saying a reasonable jury could not find. And this case is dismissed on summary judgment. And I think that's wrong. I think that at minimum, if one judge says a reasonable jury could find, that case should go to a jury. So this is an example of a civil rights case that was dismissed on summary judgment. And there's a significant problem in the federal courts with the dismissal of civil rights cases on summary judgment. So for example, there's a study by the Federal Judicial Center of the federal courts across the country. And it found that summary judgment was used more often in civil rights cases, and specifically in employment discrimination cases. Over 70% of cases were dismissed in full or in part where there was a motion for summary judgment. And so again, in employment discrimination cases, over 70% dismissed in full or in part where there was a motion for summary judgment. There's another study that was more recent, 2011, 2012, of the Atlanta federal courts. There's a shocking figure where there were race discrimination cases where someone was represented by counsel. 93% of the race discrimination cases were dismissed on summary judgment where there was a motion for summary judgment. So shocking figures. So what types of cases are being dismissed? Let me give an example of a case from my book that Professor Miller mentioned with Sandra Sprino. This is a case called Clack versus Rock. And in this case, there was evidence, it was an employment discrimination case where the employee was fired and alleged that he had been discriminated against based on his race. He's African American. And he alleged that a supervisor used all kinds of racist language, and he had testimony from another supervisor who said that that supervisor used all kinds of racist language against many African Americans and specifically against Mr. Clack. The worst racist language was used, and you can see this in a footnote in this case, that there was references to stringing him up, there was references to Black employees being lazy and good for nothing, and the employer knew about this. And this case was dismissed on summary judgment at the district court level and affirmed by the Court of Appeals. And all of the people who weighed in on this were white. The next case I want to give you is a case from my article called Customer Cast. This is about discrimination in public accommodations. And so I looked at all the cases from 1964 to the fall of 2019 where I could find on Westlaw that related to public accommodations. And one of the cases I want to just mention, but this is consistent with the rest of the case law. This is a case where there's following of African Americans in a store, in a Dick's store. And the lower court and the Court of Appeals say summary judgment in this case, even if you're followed because of your race, that as a matter of law, we're going to say that there should be summary judgment because you can make a purchase. If you can make a purchase, that's enough. It doesn't matter that you're followed because of your race. And so there are lots of cases that are mentioned in this article if you're interested, but that's an example. So this shows you examples of civil rights cases being dismissed every day on summary judgment where there are significant facts of discrimination. So the last thing I want to mention is going back to the Constitution. So there is good reason under the Constitution that this procedure should not be able to be used, especially in these factually intensive civil rights cases. So the Seventh Amendment provides, in suits of common law where the value of controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So a little known fact is this is the only place in the Constitution to refer to common law, and the United States Supreme Court has said that common law in the Seventh Amendment means the English common law in the late 18th century, which is when the Seventh Amendment was adopted. And so we in the United States adopted a jury trial based on the jury in England in the late 18th century. And so as a result, the Supreme Court has said, let's look to England to decide when there's a jury trial right. And so what we do when we look at that history, which is what I do in my article, Why Summary Judgment is Unconstitutional, as well as described also in my book, The Missing American Jury, we find that only after jury trial could a judge question the sufficiency of the evidence. So a judge could, after a trial, say that we see that the evidence is insufficient in the sense that it's very clear to us that the jury was wrong. We're going to send this to another jury. And then if the jury came up with the same result, they would never send it to another jury, but they could never overrule the jury. And I ask you, if you're interested in this, to look at the Slocum case. The Slocum case agrees with this, right? It tells us the history, but the United States Supreme Court, unfortunately, has changed over time, changed its opinion over time as to how important history is. And in questions, if anyone has any questions about this, I can tell you why I think history is so important here. So that gives you a sense of why I think summary judgment is problematic, and particularly problematic in civil rights cases. Thank you.
Thank you so much, Professor Thomas and Professor Coleman. Now we're in the Q&A portion, and I'll remind the people who are watching that if you have a question, you can input it in the Q&A function at the bottom of your screen. We have one question, and then I'm going to take moderator's privilege and ask another. So this is directed to Professor Coleman about what are your findings about the other federal rules committees?
Yeah, it's more of the same. It is very, very white. So taking all the committees in the aggregate, they are 94% white over time and 92% white currently. With respect to women, 38% of the committees are made up of women, again, in the aggregate, but that is also not the greatest news because out of the 24 individual women who are serving on those committees, only 21 of them are white women. So again, women of color are just basically not represented on these committees. Also, some committees are different than others. So in the Civil Rules Committee, you saw that work, but with the Appellate Rules Committee, for example, it's been 90% male over the course of history, and it's 71 now, and it's been 94% white, and it's 86% now. They've never had a woman of color on their committee either. And then you have the Evidence Rules Committee, which has an incredible impact on the trials that Professor Thomas wants us to have. But when you look at the Evidence Rules Committee, it is 100% white, and it always has been. And when we compare that to the fact that 38% of our federally incarcerated population is Black, I would argue that this is really, really problematic. So more of the same, a little bit of differences here and there, but basically the same as the Civil Rules Committee.
So this is a question for Professor Thomas about the sort of summary judgment and sort of stipulating, if we can, that I don't expect that the Supreme Court will sort of overturn it as being unconstitutional anytime soon, and working within the framework we have. How would you, how do you think about how to resolve the problem that you're identifying? That is, what is the policy intervention if you wanted to make sure that judges, in fact, were better at making these kinds of judgments about a deliberative multi-member body like a jury? Or do we just need to scrap the whole thing and start with something else?
Yes, I think there are kind of different levels of fix here. And, in the first instance, I get that you want me to sort of assume, and I get it, that summary judgment is not going to be found unconstitutional anytime soon. I do say that we've cared about history, right? And you know this as well as anyone, having written so many pieces on historical matters, that we care about history. The United States Supreme Court cares about history. And I think that we see an interest in this, and we see a shift even in various matters that we never thought that the United States Supreme Court would get involved with. So in the first instance, I'm going to continue to go for that, right? I'm going to continue to go for the fact that I think the United States Supreme Court should be looking at this historically and see that it has shifted, right? It accepted that this was problematic early on, such as in Slocum, but it has shifted in favor of its own authority, and it really needs to think of the jury, as I've kind of argued, as a branch of government and kind of recognize its authority. So that's the kind of and I get it. That's the tough fix. The second level of this would be that I think that we should really not be using summary judgment in these types of cases. So the types of cases I mentioned, these civil rights, factually intensive cases, there really shouldn't be use of summary judgment. It should be, like it was back in the day, that you wouldn't even bring these motions, right? When the case I mentioned earlier on, there was no summary judgment motion in that case. Why? Because people didn't grant summary judgment back then very much. And I think that we need to go back to that time, and we need some guidance, maybe by Congress or elsewhere to try to stop that. And then the last sort of idea, which I mentioned briefly, was something I call the consensus requirement, that if you have one judge say a reasonable jury could find, that case should go to a jury. And so I think that, all of these are kind of pie in the sky ideas, but I think that it's recognizing the reality of our system, which is that the reasonable jury standard is an impossible standard. Thanks.
Can I just jump in too? Because I think that Professor Thomas is being too humble, because you have a letter from Justice Scalia that might be of interest to the students.
Yeah, so back in the day, early on when I wrote this article, I wanted to interact with Justice Scalia on this issue because of his interest in history. And so as a result, there was a conference at Ohio State, and I met Justice Scalia, and I interacted with him about the issue of summary judgment. And he asked me to send him my work. And he wrote me a letter back that was positive and negative. He said, I find this persuasive, but I'm not sure what I can do about this. So of course, now that there's one less person interested in history, at least interested very, very seriously in history on the court, I think that it goes back to Professor Miller's point that this is probably not going to happen anytime soon.
So I want to ask both of you a kind of meta question. And as you know, this goes to sort of our theories of civil procedure themselves. So the tensions that both of you are highlighting here is, you have an idea of the civil procedure rules as being representational as opposed to technocratic, right? And so, as you know, in the federal system, Congress delegated to the technocrats, i.e., judges, the ability to create the rules, but some states didn't, right? Some states actually, the state legislature controls their rules of civil procedure, which we can argue would be far more representational. But are there any costs associated with that? And the other issue, I think, that Professor Thomas, your work and your suggestion at the end sort of suggests is this tension between having trans-substantive rules and having sort of bespoke rules for certain areas. So there seems to be a risk related to maybe the first category of tensions, that if you end up allowing too many bespoke rules, then it will simply replicate the power structures that exist already. That is, you'll end up with bespoke rules for, as happens for class actions for insecurities or for Wall Street, but you won't end up with bespoke rules for civil rights. So how do you guys, how do you both sort of think about these tensions of the representational versus the technocratic and the trans-substantive versus the bespoke?
Yeah, I think we're all becoming non-trans substantivists now. I think it's kind of the way that I am feeling myself starting to lean as well. But I would argue, I mean, I think I'd flip your question, Professor Miller, that what we are doing right now is not trans substantive, because we are representing really only certain kinds of litigation, and boy, are we representing them, right? And so we do have representative bodies on these committees. And I've written other work that's called 1% procedure, which is basically this argument that the most elite members of the committee have the experience in the most elite kinds of litigation. The Supreme Court is elite, and because it's just their world, the rules represent that world. And so already we are representing this kind of high level rarefied air litigation. And I think that goes for both plaintiffs and defendants. I think, like, we have more about really complex MDLs than we do about, the bread and butter class action that might exist for any, lawyers at a federal court. So I think we've already gone down that road, and the question is how to bring it back. And I think, when we get to that point where maybe one group is overrepresented on the committee in the way that I would like to see, and then we'll have to scale that back, I welcome that day. I would really love to see that happen. But for now, I think the danger in that is pretty slim. I would not like to see it go back to Congress. I think while the rulemaking structure, to me, I criticize it, I also admire it. And I only criticize it because I admire it so much and that I want to see it work the way it should. I do like the idea of having a separate body, but I don't think of these individuals who are going to be on these committees as being so one-dimensional that they only represent their race. They're experts in their field. They have a lot of other things to bring to the table. And so I don't think that we're going to have like a representational kind of rulemaking committee if I get what I want. I think we'll just have a more diverse and better functioning rule committee if I get what I want.
So I agree for the most part with everything that Professor Coleman said. The only thing I will say, and it's not something that I've thought a lot about, but I do question the ability of the Rules Committee to get the job done the way it should get the job done, given what Professor Coleman has pointed out in terms of representation. And I want to give everyone kind of just a very succinct example from the most recent sort of big rule change, and that's proportionality. So I think maybe Professor Miller may have covered this in class, but oftentimes we don't have enough time for discovery. But discovery had a very general rule as to what the scope of discovery is. And you might say, oh, what does it matter? And it matters because this is what everything's about, discovery. And what happened was this was amended relatively recently to add a requirement that the discovery has to be not just relevant, but proportional to the needs of the case, and including a lot of different factors that can be considered in deciding whether it's proportional to the needs of the case. And that's a game changer. And I'm not sure that we've seen it, change everything yet, but I think we will see it. And so in a civil rights case, a judge can consider the cost of that case, that the cost of that case is a smaller dollar amount, and decide to give less discovery in that case than in a case that has a larger dollar amount. Well, it doesn't matter if the case has a larger dollar amount or a smaller dollar amount. Oftentimes the discovery that you need may be exactly the same. If I make a lot of money, I still have, as the person who has less money still needs as much discovery in a discrimination case, for example. So the reason I bring this up is that there was huge differences in opinion between the plaintiff's bar and the defendant's bar about whether that rule should have been passed. And the makeup of the discovery committee mattered. And I think that it is very clear to me that a different makeup of the committee would not have passed that rule. Everything was going fine. And there were federal judicial center studies that said that costs weren't out of control. But there was a lot of corporate influence. And at the end of the day, this was passed. And so that is a concrete example of why Professor Coleman's work on representation matters, and why I don't know if the committee as is okay.
We've got another question. This is, I'm assuming it's directed to Professor Thomas, which is, the question is, summary judgment seems to some extent to protect the governing law, I'm assuming, from being watered down by juries that are sympathetic to parties. How would the underlying standards burdens be preserved if it is eliminated? So I think the question here is that summary judgment, I'm presuming that the motivation behind the question is that you have a standard, and the juries are not supposed to substitute their own judgments about what the law is, and that summary judgment in some way preserves that. I'm paraphrasing a little bit about the question, but summary judgment seems to be protecting the governing law being watered down by juries. How would we protect the underlying standards if it was eliminated?
Yeah, I think that is certainly something that there is, because of how kind of everyone views summary judgment, we, especially as lawyers, think of it in that way. And I think that at some level you have to back up and say to yourself, what's a legal question and what's a factual question? And in the cases that I have mentioned, and I'm just going to use this example because we could definitely have another discussion about other types of cases that are not factually intensive cases. And that's kind of a different question. But all the types of cases that I'm mentioning that get dismissed on summary judgment are cases that are highly factually intensive. And what has happened is the factual question has been changed to a legal question. That is that now we are saying that because a judge says a reasonable jury could not find for the plaintiff, and remember who that judge is, it's not a jury, it's a judge with one perspective, then that's a legal question. And it's not a legal question, it's a factual question. And at the core of all these civil rights cases is they are factual issues, not legal issues, and it's been turned on its head. I can talk to you more, like there's more to be said about cases outside of this realm, but because this particular panel is about race, those are the types of cases that we're talking about here today. You can criticize me about this outside of that, but I will tell you that, I have an answer to that too. And it may be the case that there are, someone has criticized me, people have criticized me and say, well, summary judgment is not always unconstitutional. Practically the way it's applied, it is, that's I would say, but there are very, very few cases that yes, if there is no factual dispute and you can throw the law on top of it, that yes, that would be appropriate to dismiss. And that's called the demur to the pleadings. That was prior to trial. And you can take a look at any of my work to see what that is. So I agree with that case can be dismissed prior to trial, but it's a very specific proceeding.
We have another question, and I think this is directed to Professor Coleman. Beyond federal judges, what are the other pools of people that typically end up on the Rules Committee, and what other pools might be more representative?
Yeah, that's a great question. And just a real quick piggyback on Professor Thomas's question that she had as well. Most of the studies that we have around what juries decide and what judges decide, they come out the same way. So I also think we have this idea that juries are going to go rogue, but they don't in the run of cases. The cases that we're talking about is where it's more problematic. So I think that really supports Professor Thomas's view, because it really is in this context of civil rights and race. With regard to who else is on the committee, they're mostly practitioners, and then some academics, although not very many academics. There's one reporter and then one professor member who's on the committee in most cases. So most of the people who are on the committee are lawyers. And again, there is an elitism there. So they tend to be lawyers from these bigger named law firms. Again, they tend to be partners. So we know that that's going to be problematic, because while more women and people of color are going into big firms, they're not staying and they're not being made equity partners. But it's not the case that it has to be that way. You can still be expert in the civil rules and not be at a white shoe law firm. So I think there's a way to expand our thinking about what kind of lawyers should be on the committee. Academia is also incredibly underrepresented with respect to women of color, especially, but people of color overall. So that's not going to be the greatest pool to pull from. Part of the problem, though, as with all of these things, is the way the appointments are made. So the appointments are made kind of in this inside baseball system where, for example, the Chief Justice sends out a message to all the Chief Justices of all the different circuit courts. Well, already you've narrowed your selection pool there. So it is a little bit of, nepotism maybe is too strong of a word, but it is a little bit of too much of that networking of folks who all know each other. And if you go outside of that a little bit, and I think if he just expands his view a little bit, reaches out to affinity groups or different kinds of bars across the country, he might get a more diverse pool of candidates from which to pull. I don't think we're going to be able to take away the ability of the Chief Justice to make these appointments. I think we're stuck with that. But I do think that we can put pressure on him to expand the way he does it and to be more thoughtful. And he has a little bit. I mean, there's been more pressure on him, and he has made some appointments that have been more diverse because of this push. And so I say we should continue with it and think about how else he can expand the pool of people that he's looking at.
So we have about 6 minutes remaining, and I'm really sort of intrigued by the idea of reaching out sort of beyond, sort of beyond the repeat players, as it were, in the rulemaking space. So do you think there's any reason, this is a sort of version of the technocrat maybe question, but is there any necessary reason that we would always just want judges or lawyers on these committees? I mean, what if somebody had said, what we really need to do is, get, social activists, or we need to get, suburban, suburban residents who are not lawyers, who are single mothers or something like that. What would you say about those kind of suggestions about changing up the Rules Committee?
So I think that, theoretically, those folks already have a voice in the process because, they do a situation where they publish the rules and people can comment on them. And to the extent those groups are organized, they have input. I don't think it makes sense. These are the rules of procedure, and I want to have people who are expert in procedure in that room. But this idea that you can only be expert in procedure if you practice at Leaf Cabraser or, you know, Sherman and Sterling. It's anathema to really what we know about how our lawyers conduct themselves. Like, in fact, I would argue that, you know, my students who go out and have mid-sized law firms or solo law firms know more about true discovery than some of the same level associates at another big firm, because they're actually running discovery, they're doing discovery, they're not just sitting there reviewing it. So again, there's this idea that we think of expertise in this one way, and I would push back on that. Now, do I think that we need to represent different constituencies with respect to this social action? No, I think again, those groups can work through different plaintiff and defense bars and different groups to advocate for how that particular rule might impact them. But as far as how the rules work on the ground, I think we can do a much better job of representing what actually happens in federal courts than we do with the way the committees are constituted now.
Professor Thomas, did you want to weigh in?
No, I think she covered it.
So this is a question for Professor Thomas, because I find your work fascinating, and especially, you know, thinking through all the ways in which you have these sort of judicial veto gates to the jury. But the jury itself, you know, if you think about it, has its own set of problems in terms of how it does its work. And, you know, to the extent that there are anchoring effects that happen with evidence that's presented to the jury, to the extent that you end up with all kinds of biases that's presented to the jury that can infect how they make a decision. That is, they know one thing that's really bad about a plaintiff, and that ends up affecting how they view the entire case, for example. So how do you think through those aspects, assuming that more cases went to the jury about, you know, what we might think of as bias or cognitive biases in the jury room itself?
Yeah, sure. So I think that the way I want to kind of like frame this is, you know, who can decide, right? So we can have a jury decide, we can have a judge decide, we can even, in some circumstances, we have the executive decide. We have SEC cases, right, that have been shifted from juries to the SEC itself to decide. So there are all these different bodies that can decide, and so who should decide? And you know, Professor Miller points out that juries have bias, and that's true, we know, and also have problems with heuristics, such as anchoring. But as Professor Coleman pointed out, we know that judges and juries generally agree. There's plenty of studies on that. We also know there are plenty of studies that show judges and juries have the same bias, same heuristic problems. So they all engage in anchoring. They all engage in other types of heuristic types of issues. And so basically people, judges and juries are people, you know, are constituting, they're all people, the people who are in these bodies. And so the question is, you know, who should decide between these groups that have the same types of bias? And judges, we know, even in the federal courts, they're subject to potential promotion. They have repeat players coming before them. And juries don't have that. For the most part, outside of a very unusual case that goes to the media, you know, that's in the media, juries have no bias. They're specifically picked out not to have bias in a particular case, whereas we don't actually do that same type of picking with respect to judges. And so I'd say because of all of these reasons, the jury was never considered to be a perfect decision maker, but it's the best decision maker, and it has to decide unanimously. You know, it has to decide unanimously. So that's you know, for the most part. And so I think that's it's another good check in the system.
Well, this has been excellent, and I really appreciate you both, taking time out of your day in different time zones to come speak to us about your research and about this really critical issue about race and civil procedure. Thank you, Professor Thomas. Thank you, Professor Coleman.
Thank you so much.
Thank you.
And thank you for tuning in to this session on race in the 1L curriculum, civil procedure. Our next piece in the series, our next part of the series will be on contracts. That will be on Thursday, January the 28th at 12:30 p.m. And hopefully you will be able to tune into that or watch it on the recording. Thank you very much and have a great rest of the day.